Hello, and thank you for watching. My name is Bradford Roberts, Principal Broker, Founder, and Owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. Okay, folks, so the first thing I'd like to talk about in the video today is what you can versus what you cannot do with a property management permit when it comes to rentals. So I want you to think of a rental transaction very much like a purchase and sale transaction. And what I mean is this: you can work with your client, you can search for properties, you can show properties, you can negotiate those properties, you can draft paperwork, and you can process the transaction all the way up through the point of conveyance. So in a purchase and sale transaction, you cannot get involved in anything that might be going on after the sale closes, right? As an example, a week after a property closes escrow, you discover that the buyer has some issues with the condition of the house. Maybe the seller didn't disclose something on the SRPD or whatever. You can't get involved at that point, right? Your services have terminated at the time of conveyance of the property. When it comes to a rental transaction, the same thing is true unless you have a property management permit. So again, you can work with the client, put them in a rental, negotiate the lease, even attend the lease signing if you want, help them with the application process and all of that. But once that lease has been signed and we have legal conveyance of the property from the property owner to the tenant, you cannot be involved in that process anymore. So after that tenant takes possession of the property, if something happens, they move in and they discover the air conditioner doesn't get cold or something like that, all you can do is direct them to the property manager if there is one, or to the property owner. But if you're not a property manager, there's nothing you can do to be involved anymore past the point of conveyance. And I should mention what a courtesy listing is. A courtesy listing is a rental listing by a non-property manager. So as a regular real estate licensee without a property management permit, you can also represent a landlord who wishes to rent out his property. You can take the listing agreement, you can put the property in MLS, you could put a sign, you could show it, you could procure a tenant. But again, from the time of conveyance forward, you are out of the transaction. There's a myth that a courtesy listing is one that you're doing for free. That is not what a courtesy listing is. It's simply a rental listing by a real estate licensee who is not a property manager. TR Realty does not do room rentals, and we also do not do short-term rentals, meaning 30 days or less. Those are actually considered in the state of Nevada to be a business, and they are not a real estate service at all. And therefore, we don't provide them, and we also don't work with Airbnb because of the short-term component of their business model. TR Realty does work both with the Housing Choice Vouchers program, which used to be called Section 8, by the way. The term Section 8 is no longer used. And we also work with something called HUD-VASH. HUD-VASH stands for Housing and Urban Development, Veterans Administration, Subsidized Housing. So it is a partnership between those two governmental agencies, HUD and the VA. And very much like the Housing Choice Vouchers program is for those who don't have adequate income to pay their rent, the HUD-VASH program is for military veterans who don't have adequate income to pay their rent. Just so you know, the HUD-VASH program, even though it's a federal program, is administered locally through our VA office. Now, here in Nevada, the Housing Choice Vouchers program, which, as I mentioned, used to be called Section 8, comes from the Southern Nevada Regional Housing Authority. So if anyone ever approached you and asked where they might be able to get some assistance on their rent, you probably want to point them to the Regional Housing Authority. The Housing Authority, while I'm on this topic, I should mention, typically pays 70% of the rent. and the tenant pays the other 30% of the rent. But the rent amount has to be approved by the housing authority. And there cannot be any payment over and above the approved rent without the consent of the housing authority. That is fraud, and we certainly don't allow that. And if anyone watching this video is looking for Section 8 or housing authority properties, the website to visit is www.gosection8.com, gosection8.com. So they've changed the name of Section 8 to the Housing Choice Vouchers Program, but they have not changed the website. Just thought I'd point that out. Okay, let's move on to some rental concepts that I'd like to discuss with you today. In the state of Nevada, there is no limit to the number of persons who could occupy a residence. So there used to be some local ordinances and that sort of thing, but those were considered discriminatory, so they have been taken away. So legally, there's no limit to the number of persons who could occupy a residential dwelling. However, most property managers, this is just kind of a rule of thumb, it's not a law, but most property managers will set a limit of 2 adults per bedroom plus 1. So in other words, if you had a 3-bedroom home, 2 adults per bedroom would be 6, plus 1 would be 7 adults in that property. Again, just a rule of thumb, not a law. And I need to talk about a sensitive topic. I need to talk about marijuana. Marijuana, which has come a long way for some of you. We cannot regulate or prohibit the use of marijuana. Right now, we've got a kind of a mixed bag of laws. We've got first we had medicinal marijuana that was legal in Nevada. Then we had recreational marijuana that was legal in Nevada. Then we had, despite the state laws that have been lifted, we still had a federal prohibition. Marijuana was still considered a prohibited substance. So we had a disparity of opinion between the state and the federal government. Now there's been progress, if you want to call it that, on a federal level as well to decriminalize marijuana. But let's talk about this not from an ethical standpoint, not from a legal standpoint. Let's talk about it from a real estate standpoint. So we cannot prevent the use of marijuana. However, we can prevent smoking. We have every right to make a rental property a non-smoking property, which means that either they would use consumables or they would smoke marijuana outside. So that is the way that we can keep some control over the property, by making the property a non-smoking property. I also need to talk about service animals and emotional support animals. ESAs, as they are known, they cannot be excluded from housing. And service animals and emotional support animals are not subject to breed restrictions or weight restrictions. A property manager or landlord cannot collect a pet deposit, charge a pet fee or pet rent or anything like that, for a very, very simple reason. A service animal or an emotional support animal is not a pet. And I get questions all the time. Yeah, but what about? No, there's no what about. Very simply, a service animal or emotional support animal is not a pet, is not subject to any of the restrictions, any of the rules, any of the fees that would apply to pets, okay? Very clear and very simple. A service animal is not a pet. The next thing I want to talk about here is criminal history. Now, forever and ever and ever, property managers typically had a policy that when they ran someone's background check, if a criminal history appeared on the record, they had no problem issuing a denial for that housing. In other words, a blanket policy was acceptable. However, recently, HUD issued a memo that said, a blanket policy on criminal history might be considered discriminatory at this point. So in order to use someone's criminal history as a reason to deny their housing, What we would have to prove is that the particular criminal history, whatever that person has on their record, would either be a threat to the property or a threat to nearby residents. Okay, I don't want to get into an ethics debate here about, which crimes are more serious than other crimes or that sort of thing. But if you're going to deny someone housing because of a criminal history, I think the question you should ask yourself is, could you defend in court, because you never know, it might get there, right? Could you defend that denial based on that particular criminal history, right? If somebody was arrested for shoplifting 25 years ago, they stole a loaf of bread from a supermarket. They got caught, they were arrested, they were convicted of shoplifting a loaf of bread 25 years ago. And I'm certainly, again, I'm not engaging in an ethics debate. I'm not saying what they did was right. However, could you really say that that poses a threat to the property or poses a threat to a nearby residents, right? You're probably not going to win that debate in front of a judge. So there needs to be a direct correlation between, the particular type of criminal history that somebody has and the grounds for denial. Again, you really need to ask yourself that question, look in the mirror and ask yourself, if I were in a courtroom right now in front of a judge, if this tenant, sued me for discrimination because I denied housing based on criminal history, could I justifiably defend myself that the particular criminal history is a threat to the property or a threat to the neighbors? If you can't do that, folks, it would be pretty foolish to deny housing solely based on someone's criminal history. Nevada law says that the security deposit on a residential property cannot exceed 3 times the monthly rent. So if you're renting a property for $1,500, the maximum security deposit that you can ask the tenant to post obviously would be $4,500. And also, there's a relatively new law in Nevada that states late fees cannot exceed 5% of the monthly rent. And we're going to circle back a bit later in this video series and talk about the paperwork on that, because it has affected the way we do things in the property management and real estate. So again, Nevada law says the late fees en toto, right, cumulatively, no matter how you wish to define those late fees, cannot exceed 5% of the monthly rent. Oh, and speaking of the monthly rent, I should let you know where we are right now. In Southern Nevada, the median rent right now is about $1,650 a month. Let's talk about the difference between the word deposit and the word fee. I know they seem pretty obvious. However, when I'm in MLS, I see these words used interchangeably, and I see them used incorrectly. So I'd like to do my part, at least, to explain to the viewers of this video how to use those words correctly. A deposit is potentially refundable if certain conditions are met. So therefore, there's no such thing as a non-refundable deposit. No, that's not what a deposit is. A deposit, by nature, by definition, is potentially refundable under certain circumstances. So to give you an example, if a tenant has to put up a cleaning deposit, that is to guarantee that the property is clean upon move out. If the property is not clean, the deposit may be forfeit. However, if the property is clean, that deposit is refundable to that tenant. Versus the word fee. A fee is non-refundable. There's no such thing as a refundable fee. It doesn't work that way. That would make it a deposit. So when we come to a cleaning fee, if the tenant is asked to pay a cleaning fee, there should be no expectation that that cleaning fee will ever be returned to the tenant, okay? So deposit, potentially refundable. Fee, no expectation of refundability. I also want to talk about the difference between the word applicant and the word occupant. Words I see used interchangeably, but they're actually different in the world of real estate. An applicant for a rental property is a responsible person. It's someone whose background is going to be checked, whose income is going to be checked, employment is going to be checked. They are going to be responsible in full or in part for the lease that they sign. Versus an occupant, which is someone who is just living on the property, such as a minor, such as someone without any income. That person would be considered an occupant. Now, at most companies, including TR Realty, if that occupant is 18 years old or above, we're still going to do a background check because we want to look at other things. Criminal history is probably first on my list there. So don't think that if someone is an occupant, they're exempt from the background check. They're not exempt from it, but they're probably exempt from, having to contribute income as a way of getting approved for that rental property. So applicant, responsible person; occupant, just someone who's going to be living there on the property. And you can probably assume that most occupants are minors, right? I want to talk about the concept of rent control, something as of right now we don't have in our area. But, prime example of rent control would be the city of New York. The city of New York sets rent rates. Now, why am I talking about New York? Well, there's a lot of New Yorkers living in Nevada. And sometimes people come and they think, there might be some rent control or something like that in place. There's discussion of it in the legislature right now. I doubt it will go very far in the state of Nevada, knowing kind of the tenor of this state. But we have no rent control, or we also don't have anything called rent stabilization. Rent stabilization also occurs in a place like New York City, as an example, where the city will set the maximum amount that you can increase the rent every year. If we get any kind of regulations on rent in Nevada, it would probably be rent stabilization way before it would be rent control. So rent stabilization, meaning the jurisdiction, the city, the county, the state, whatever, sets the maximum rate increases every year, versus rent control, where they actually set the acceptable rent, kind of like the Housing Choice Voucher Program, if you will. So what that means in summary is that in the state of Nevada, upon lease renewal, the landlord has the right to increase the rent as much as he wants. Absolutely. He could take a $1,200 rental property and he could ask for $4,000 at the time your lease renews. You don't like it? Move out. There are no laws to protect the tenant from those egregious type of increases upon lease renewal. The landlord can ask whatever he thinks the market will bear. I would consider doing a walkthrough with your renters for their benefit and yours. And I would consider using a form that I'm going to go over in a minute called a property condition report, a PCR. So this is why I'm recommending this, okay? At the beginning of this video, I said that once there is an effective lease on the property, tenant moves into the property, unless you're a property manager, you cannot be involved anymore. So if the tenant moves in and the next day they discover the stove doesn't work or the hot water heater doesn't work or something like that, even though you can't be involved, you know you're going to get that call, right? That tenant is going to come right back to you. And the tenant doesn't want to hear, hey, I don't have a property management permit as per Nevada law. I can't assist you with this. They just know you're the person who put them in the property. For them, you're the face of the property. And they're going to come to you with their issues, okay? One of the ways to stave off this kind of problem in the future, to stave off your tenant from being angry with you and from having problems with their property manager or property owner, is to use the PCR. So it is our first handout in this video series. let's go ahead and get that PCR in front of us, okay? Okay, looking at that property condition report, it's a 10-page form, as you can clearly see, and I'm not going to spend a ton of time on this, but there's some highlights I'd like to bring to your attention. It says at the top of the form, the purpose of this report is to note the current condition of the premises. This is not a repair list, right? Bold, capital letters, underlined, this is not a repair list. Should you wish to make a notation regarding the condition of each of the line items, please use the comment section. So what they're talking about here is very much like if you rented a car. If you went to some car rental agency, and we all know the names of those, right? And you sign the paperwork to rent a car, and you get that car off of their lot, and you look at the car and you realize, wow, there's a scratch down the driver's door, there's a stain on the back seat, there's a dent in the front fender. If you don't mark those conditions of that vehicle, there's no way to prevent yourself from getting charged with that damage when you bring that car back. It's going to be their word versus your word. They're going to say, hey, you brought the car back with a scratch, a stain, and a dent. You're going to argue, hey, these things existed when I got the car. And folks, that is why when we rent a car, we always mark any dents, scratches, stains, etc. on the vehicle so that we are not charged with those things. When you pick up a rent-a-car, they're not going to fix those things before you drive it off the lot, right? So I want you to think of that when it comes to the PCR. And that's why it says here, this is not a repair list. So the purpose of the PCR, folks, is to document the current condition of the property. And this form is to be retained by whoever is representing the tenant. This form is to be retained by whoever represents the tenant, but very importantly, it must be retained by the tenant himself. Why? Well, a year later or whenever the time comes that the tenant is going to move out of the property, whoever might be the property manager or owner of that time, and it could easily change from the person who's the property manager or the property owner right now. Whoever at that time is in charge of making a decision whether that tenant is entitled to their security deposit, we need to have the proper documentation to demonstrate to them that we did not cause the damage, right? So that is the point of the PCR. We have that documentation, and if some or all of that tenant's security deposit were retained by the owner or manager at the time of move out, the tenant is now in a defensible position. They have the necessary documentation. And that's why when we do a PCR, folks, not only should we do the form, but we should take photos of any of the deficiencies as well. Sometimes it's difficult to explain in words. It's much easier to simply have photographs of the existing condition of the property. And then it goes on, there's a box there for us to put the address, the name of the residence, the move-in date, as well as the anticipated move-out date. And then there's something there that says, this report is due on. I hate that thing. I know why it's there. This form was prepared and provided by our association, our union, if you will. Our association wants to do things to protect us, and I understand that. The reason they put this report is due on, and then there's a line where you're supposed to put a date, is because so many property managers will not take the time to do a walkthrough with the incoming tenant. What a mistake that is. I talked about that in my video series 9, which is about property management. So this item is in here. This report is due on some date because literally property managers will give this blank form to a tenant, hand it to them or email it to them or fax it to them and say, go fill this out on your own, and return it to me in a couple of days or whatever. So I think that's pretty foolish. I think that's pretty lazy. But that is why this is included. So that would only be used if there were no walkthrough with a property owner or a property manager. Okay, we get into the meat of the form now. The first section, as you can clearly see, is the exterior front, and then the living room. And the form goes on section by section. Page 2, family room, dining room, den, starts to go into the kitchen and the hall and the bathrooms and the bedrooms, etc. Notice that each page requires initials on the bottom of it. And I'd like to bring your attention all the way to page 10. On page 10, there is a blank section where the tenant, yes, the tenant, not the agent, can make any other remarks he wishes to make, comment on anything else, maybe that wasn't itemized on the form. And then halfway down on page 10, it says property condition report must be returned by the date noted on page 1, or all items are deemed acceptable and tenant will be responsible for any damaged or non-working items. If you were listening to my video when I started talking about this form a couple of minutes ago, this language would make perfect sense to you. And then if there's an agent representing the tenant there, tenant signatures, don't forget the initials all the way down the bottom of page 10. Agent should take a copy. If there's a property manager, that property manager should get a copy. If not, the owner should get a copy of this. And most importantly, the tenant needs to preserve a copy of this PCR for their records. And I know, we're looking down the road a year or two or longer in some cases before a tenant moves out of a property. It's difficult to retain, to find this document when you need it. But folks, it's really, really important that tenants hang on to this. Otherwise, they are at the mercy of the property manager or owner at the time of move out, who may wish to ding their security deposit for repairs, for deficiencies, for problems that the tenant never even caused himself. I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.